Hey, what's up, guys? Coming to you from outside today because my office is having some work done with the new air conditioner being installed, and I can't be in there while those guys are working. So we're here in the trees, true Mother Nature, and we are talking about the January 6th Capitol protesters. Rioters, rabble-rousers, freedom fighters, I don't care what you call them. I'm sure you're going to send me a message in the comments and tell me that I've labeled them wrong. That's fine. What is important to me is that you know who I'm talking about. We're talking about people charged with crimes related to the January 6th event at the Capitol building, okay? Because we've got some pretty interesting developments going on, and it kind of feeds in to the political nature of this prosecution and the pitfalls of doing political prosecutions if things play out the way they're supposed to. So let's talk about the government's withholding of something called exculpatory evidence and what that could mean for various defendants. Hey, I'm Nick Rekieta of Rekieta Law, a small law firm in central Minnesota. I'm a lawyer. I'm also a legal and political commentator on YouTube and on Odyssey. Wherever you're watching, hit like, hit subscribe, turn on those notifications. I wouldn't want you to miss any videos, okay? Especially not ones out here in the trees, right? All right, here we go. Here we go. Turns out there's potential that the government has withheld evidence in their prosecution. I know, go figure, right? It's like the prosecutors want to sculpt a particular narrative about the defendants, and that narrative could be unreasonably hampered by the disclosure of certain evidence. This is called exculpatory evidence. That's any evidence which would tend to cast the defendant in a more favorable light than the prosecutor is intending. Now, there's actually a rule about this where prosecutors have an obligation under law to turn over any exculpatory evidence that may be in their possession. And it doesn't matter if they do so, if they withhold that evidence intentionally or unintentionally, because if that evidence would have helped the defendant, they have a duty to provide that evidence. This is part of that whole innocent until proven guilty thing, and having a fair court and your right to due process and adequate representation. All of this feeds into the fact that the government has to give you the information that it has that might make you look less guilty. And in the January 6th stuff, it seems like there's a bunch of evidence that the government has in its possession, like, you know, evidence that maybe the Capitol Police let several of the protesters in, told them they could go in, fist bumping the protesters, high-fiving the protesters, and other sorts of events like that. Now, when this happens, when the defense finds out that the government has withheld something, they make a motion under something called the Brady Rule. And this is from a case, Brady versus, it doesn't really matter, Massachusetts, Maryland, an M state maybe? I don't remember. But the Brady Rule is basically this. It's a test to determine whether or not the exculpatory evidence that was not provided would potentially have changed the outcome of the case. But it's a little bit more specific than that. Okay, so first things first. So the job of this rule is to determine first whether or not prejudice exists, all right? So this is kind of the key in any of these evidence issues that come up. I mean, it's really easy to say, well, the government withheld evidence, so they should lose. I actually agree. Or that rights were violated, so someone should automatically prevail against the government. I mean, if their constitutional rights were infringed, then the government should lose. I agree with that. The courts, however, don't actually take it that far. Courts suggest that prejudice must ensue from the violation. So if rights were infringed, but that infringement of rights didn't hamper the defendant's ability to defend themselves, then it's not an infringement, and therefore the defendant at that point is still under the state's thumb. if for lack of a better expression, okay? So that's the first part of this Brady rule, is to find out whether or not this actually prejudiced the defendant. Because if it didn't prejudice the defendant and the government withheld it, then it doesn't really matter, right? Like, I guess the idea is, if at the time the guy was robbing the bank, if he helped Girl Scouts across the street, that's not really material to whether or not he robbed the bank. And so therefore, the evidence that he helped Girl Scouts across the street right before robbing a bank doesn't have anything to do with the underlying crime, and it doesn't prejudice his defense to not have that exculpatory evidence included, okay? But if they are able to find and show, if the defense is able to show that the prejudice has occurred, then the evidence that they're going up against can be suppressed, which could ultimately lead to either, like I said, reduced charges, reduced sentence, or even a full dismissal of the case. If the government doesn't have evidence to bring against someone because it's all being suppressed, because they failed to disclose exculpatory evidence, which would cast them in a different light, then they have no case and it gets dismissed and the person is free to go. Okay, so then we have some subsequent cases to Brady that help kind of define how you go about showing whether or not the evidence that is allegedly exculpatory actually is exculpatory, and they developed some tests for this. Now, first of all, it's not about the sufficiency of the evidence. That's a pretty important thing here. It doesn't matter if the evidence would have overturned the case on its own. It just matters if the evidence would have undermined the government's case at all, would have given them doubts to their ability to prosecute the case. You don't have to show that if this evidence existed, that you would be 100% innocent. You just have to show that the government had a reason to not give you that evidence. And importantly, it again doesn't matter whether they wanted to suppress it, whether it was intentional or unintentional, because the government has an obligation and your right to due process is so strong. Plus, it would be very easy for the government to say, oh, well, shucks, we just didn't know that we had it, weird, in our case file. They have a duty to know what they have in their case file, and that is very, very important to all of this, okay? So, the question here that the Capitol protesters will have to figure out is whether or not the government withholding evidence from them about various events that happened leading up to those getting into the Capitol protests. Like, for example, Capitol Police letting them in. For example, Capitol Police high-fiving and fist-bumping protesters as they were walking past and as they were going in, telling jokes and having a jovial time. Would that undermine the prosecution's ability to prosecute this case against these defendants? Well, it's probably going to depend in some part on the defendants and where they were. For example, if you have video of a defendant punching Capitol Police in the face, like while they're on the ground, I don't think this video exists, but maybe it does. I don't know. But hypothetically, if you have that kind of video, he's got him in an MMA lock and he's just pounding him on the ground, then I don't know if a Capitol Police officer fist bumping someone else is going to be sufficient exculpatory evidence to undermine the government's case in that particular defendant's issue. However, if you have someone charged with trespassing, not like beating a police officer, and all you have is footage of them inside the Capitol running around, taking videos, sitting on Pelosi's desk or something like that, and you withhold the fact that Capitol Police let some of the protesters in or were shaking their hands and fist bumping them and having jovial conversations during this encounter, then yeah, I think you've got a much, much different question at that point. There's a big difference between going into a building and intentionally destroying things, or, trying to light a fire or harming Capitol Police or something like that. And the exculpatory evidence is going to have a big difference based on what criminal charges are facing the defendant at that point. So just wanted to let you guys know that is kind of coming out now, that the government has been withholding this evidence against some of these Capitol protesters, and that may end up with some pretty interesting results for some of them. like full acquittals on things like trespassing, and potentially on things like destruction of property or intent to interfere with Congress while it's in session. If they're able to show that they were let in, or that at least some of the protesters were let in, and there's reasonable doubt as to whether or not these people stormed it, if that evidence would tend to paint the defendant in a more optimal light and would give rise to doubt of the prosecution's ability to win, then they could get their charges dismissed, or they could have the charges reduced to something more akin to negligence rather than intentionality, if that were to apply in the particular charges. There's a whole bunch of charges out there, though, so there's a whole bunch of cases and a whole bunch of opportunity to do that. The real tragedy here is that some people will have taken plea deals, or will even, after today, take plea deals rather than go after the government for its failure to disclose this stuff, and they will be kneecapping their own ability to pursue justice and due process. They'll forfeit their due process rights by taking a plea deal, and that will be something that will be very, very hard for them to undo, even if the government acted in a clearly inappropriate way. But that's what I got for you guys today. I hope you found this video a little bit informative on the topics and a little educational on the subject. It's a very high-level review. Look, these things get really detailed, and you can do whole semesters of classes on some of this stuff. But I wanted to give you a kind of a bird's eye view of what's been going on in those cases and what potential evidentiary issues the prosecution is running into at this point. So why don't you drop a comment down below? Tell me what you think. It's always weird for me to do videos outside. I'm outside of my comfort zone, but we'll talk to you soon. Have a good day, guys. Peace. Peace.